many couples who are fighting custody battles in two different countries. One child, two countries, two court orders. What happens next? Is an Indian court bound by an order of a foreign court? Now, the first question I would like to deal with is, can one country ignore another country's court order? The answer is no. There is something called comity of the courts, which means that Indian courts will respect the orders of foreign courts, and foreign courts also have to respect the orders of Indian courts. But what happens in the case of a child? Now, Indian courts have by and large kept only one thing in mind, and that is the best interest of the child must be given priority. There are several cases where the husband and wife who are fighting with each other make the custody battle so twisted and so painful for the child without realizing that these are going to leave irreparable scars on the child's mind, his psychology, and probably his future. So, let us understand what happens when there is a legal clash between jurisdictions and the outcome of cross-border custody disputes when it affects India. I would like to begin with the case Ruchi Majoo versus Sanjeev Majoo. Supreme Court of India decided this in 2011. Both parents were Indian origin, but they were settled in the United States. Their son was born in the US, and as such he was an American citizen. During a visit to India, the parties had a major setback and they decided that they wanted to part company with each other. The mother decided to stay back with the child in India. She was in New Delhi. The father was very upset with the whole situation because he also wanted the custody of the child. He therefore returned to the United States and went to a Californian court, asked the court to grant him custody, and also reported to the court that the mother had abducted the child. Now ask yourself, if a US court has already decided the case, can we think that the case is over? The answer is no. Because the mother was in India, she also filed a custody petition in the Delhi courts. Now what do we have? A situation where there is one child, two countries and two conflicting orders. This is where things get complicated. The key question before the Supreme Court of India was, is India bound by a foreign court's custody order? If yes, the father wins instantly. If no, everything changes. The court first had to look at the jurisdiction. Under Indian law, custody cases are decided where the child ordinarily resides. In this particular case, the child was living in Delhi, going to school in Delhi, was socially settled in Delhi. So the Supreme Court of India held that India had jurisdiction. But what about the US court order? Can a country simply ignore another court's judgment? This is a very important aspect of law, and this is where the important legal principle of comity of courts comes in. Basically, it is said that internationally countries must respect each other's legal decisions. But the Supreme Court of India made something very clear. Respect does not mean automatic enforcement. Indian courts have to make their own independent decisions, especially when the future of a child is concerned. So the case is not about nationality, not about which court has decided first. What actually matters is, where does the welfare of the child lie? Does it lie in the foreign jurisdiction where one parent is living? Does it lie in the Indian jurisdiction where one parent is living? Or does it lie where the child wants to live? The court always looks at only one principle, and this principle, I would say, is applicable across the world, and that is what is best for the child. Having considered that, the court found that the child was well settled in India. He was going to a school in New Delhi. He was comfortable with his mother. So finally, the court gave custody to the mother with visitation rights to the father. So although there is comity of courts, but still, in a case where a child is concerned, Indian courts have always felt that it is more important to see the future of the child rather than see which court and which judgment should be enforced. There are other recent Supreme Court rulings in India that have reinforced this approach. foreign custody orders are considered not always binding but definitely persuasive. Courts must always conduct an independent welfare analysis. Increasing focus is now given to emotional stability, continuity in a child's life, and meaningful contact with both parents. So, the final takeaway is if there is a cross border battle, the real winner isn't the parents, it is the child's best interest. With this in mind, the courts have passed order after order, and Ruchi Majoo versus Sanjeev Majoo was the first in a line of several judgments. After that, we have a judgment called V. Ravichandran versus Union of India, where the child was removed from USA to India by the mother. Father sought return via habeas corpus petition. Courts, however, felt that the summary return of the child to the foreign jurisdiction would not serve the welfare of the child, and they therefore did not allow the child to go back to the US. Again, in another judgment, Nityanand Raghavan versus State of Delhi, 2017 judgment, the child was brought back from UK to India by the mother. Father relied on the UK court custodies. The foreign judgment, the courts in India held that the foreign judgment was only a factor, not a binding precedent. Courts therefore must decide, has the child settled in India? Will return cause him harm, or will staying in India be better for him? So, summary is return versus welfare. Ultimately, welfare always wins. In another judgment, Pratik Gupta versus Shilpi Gupta, 2017, the child was retained in India. US courts existed. Father sought return to US. However, again, welfare versus comity of courts. Even if foreign court has jurisdiction, Indian court can refuse. So again, the approach was child-centric. Yet another judgment, Kanika Goyal versus State, 2018. Child was brought from US to India. Conflicting custody claims. Foreign decree was considered, but Indian courts had to assess what was in the best interest of the child. One more judgment that's very important is Lahiri Sakha Muri versus Shobhan Kodali, which is a 2019 judgment. Again, child removed from USA to India, father chose return. Held if the child recently removed, return can be ordered, but if the child has been staying in India for long, then the welfare inquiry must be done. Hence, by and large, courts have always been of the opinion that a child has the right to love of both parents. Courts must ensure that both parents are always connected if they are in different countries by video calls, by regular calls, and regular interaction. And what the court wants to do is shift the battle from custody to shared parenting model. In a recent judgment, Surya Swaminathan versus State, it was again a cross border dispute for a child and again competing jurisdiction issues. Court held that litigants must avoid forum shopping, welfare inquiry cannot be bypassed, and focus must be on preventing misuse of jurisdiction. So there are several other judicial orders that have been passed by the Supreme Court of India. By and large, the principle is very simple. Welfare of the child comes first. If you have any queries on this topic, because today child custody between two different countries is a common thing, we see it all the time, please feel free to comment and we shall definitely respond to you. If you have found this video useful, please like, share and subscribe to our channel, and please circulate this with as many people as you can, because this is one area of the law which is always in conflict when parents are in two different jurisdictions. Sadly, most parents are only concerned with who will win, not that the child should win. Please follow us for further episodes on this topic. And if you have any topic that you want us to speak on, you are welcome to mention it in the comments and we will definitely make an episode on that particular subject. Thank you.